Harrison. Thank you.
Chair. The Inquiry Council indicated to you on the first day of the hearing that I represent a number of core participants instructed by the firm of solicitors Duncan Lewis. Those core participants are D1527, D1851, D1914, D2077 and D1538. The latter is a core participant who was only added this week, and so I will leave his case to the second phase. You're going to hear submissions. You're going to hear submissions from me in opening of a generic nature, and from Mr. Goodman on behalf of D1527, and from Miss Morris in respect of Nathan Ward. But my focus is very much on the generic. And I'm going to start with what we have heard on a number of occasions said. This is an inquiry into Article 3 mistreatment, the prohibition on torture, inhuman or degrading treatment. And whilst this inquiry will understand that that critical phrase comes from the European Convention on Human Rights, it should be understood, not just here but beyond, that it is a key common law protection well entrenched in English law, that any form of torture or other cruel or inhuman treatment is utterly repugnant and contrary to fundamental principles of English law. It is repugnant also to reason, justice and humanity. Yet we have seen already, if only in snapshot form, from the panorama footage, that form of abhorrent and repugnant treatment was taking place in a removal centre not more than 10 miles from this place. Such cruelty, as we have graphically seen, serves only to destroy the moral and physical integrity of the victim, subjecting them to pain, severe mental anguish, and stripping them of their human dignity. We can also see that it serves to degrade those who engaged in the practice, as well as those who instigate it, encouraged it, colluded or acquiesced in it. And it's in all those forms of responsibility that this inquiry must address its mind. What we say the inquiry will find is that once mistreatment, abuse and fundamental disrespect for human rights becomes acclimatised, as surely it was in Brook House, not just during the period of this investigation, but probably for many months, if not years before, it further hardens and brutalises all those who have become accustomed to it, and it corrupts the whole. That's why we're here concerned not with the aberrant acts of a few isolated individuals, but with an entire institutional culture and practice that was ingrained, well known, and allowed to continue with impunity until the good fortune of the courage of Mr. Tully to use his camera to bring into the light the darkness that was Brook House. In looking at the importance of the protection against treatment which is torture, inhuman or degrading, we can go back in this country to 1689. That's the first time that legally sanctioned ill treatment was prohibited by law. It was at a time when Parliament recognised that in circumstances where you have extraordinary powers being exercised by the executive, at that time it was the king, that's incompatible with the liberty of the subject. We say, although this inquiry is not directly concerned with the wider questions of immigration detention, it is important to recognise that we start off here with an extraordinary draconian power, that of executive administrative detention, normally only used in times of war or public emergency, but here used on a mundane and regular basis with individuals held for indeterminate periods without charge or trial. This inquiry cannot ignore or disregard that that's the starting point for understanding the rest. That's because when you come to see, as we say the evidence will show, the profound weaknesses in the legal protections and the safeguards for detainees' fundamental rights, and indeed in the attitudes of those who had responsibility for detaining them and looking after them on the ground in Brook House, it is that fundamental lack of a robust legal protection that explains some of the consequences that we're now investigating. It's also important because you will have seen already from some of the extracts of the evidence that being detained indeterminately or indefinitely impacts on the detainee's own experience. You will also know that based on Professor Bosworth's study for the first Shaw Review, that detention which is indeterminate has a negative impact on a detainee's mental health, and that impact increases the longer the person is in detention. It was also established by Professor Bosworth's first study that it's not just the length of detention that impacts negatively on mental health, it is also in circumstances where that individual has pre-existing trauma, such as torture or other forms of ill treatment, and where they already have pre-existing mental illness. However, you will also hear from detainees, former detainees, who had no mental illness when they went into detention, but nevertheless, as a result of relatively short periods of detention, their mental health was damaged irredeemably and broken. That will be the case of D1851, which I'll come to shortly. What's significant then about this context is that when you're viewing the evidence and when you're asking yourself how this happened and why it happened, you have to start from the proposition that what was necessary here was rigorous, robust enforcement of safeguards in policy and practice, as well as the highest standards of governance, oversight, management, and vigilance in ensuring compliance. The evidence, however, points exactly and uncontrovertibly, categorically, to the opposite at all levels within both the Home Office and G4S. And it is important to recognise that whilst we will focus on this phase in finding the facts on the acts of those in the detention centre, this inquiry must look further. It must look higher and it must look to the top within director level and at senior management level, and it must also consider political responsibility for the oversight of a system that was so fundamentally flawed and so damaging to those it was supposed to protect. It is for this reason why we say at the outset it is critically important for your task chair to understand the role that the safeguards play. You've heard about Rule 34 and Rule 35 of the detention centre rules and the adults at risk policy. It's those frameworks that fill the huge gap that there is when one has administrative detention. They were intended to ensure that within 24 hours of entry into an immigration removal centre, a doctor had assessed you, examined your your mental and physical health, and had made a report of any evidence that raised a concern that continued detention would cause injury, suicide, where there was suicidal ideation or a history of torture. It wasn't supposed to happen many weeks later. It was supposed to happen within 24 hours of arriving in the detention centre. That is because it is well recognised that in all those three categories, continued detention is likely, as Professor Bosworth identified, to cause relatively rapid, significant deterioration in your mental health. We have already heard from counsel to the inquiry that those protections were fundamentally failing. They had been failing for over 15 years. And so it will be an important and critical part of the inquiry's analysis to understand why that was. And in that regard, primary responsibility is going to be held by the Home Office. And it's not just an operational failure, because what you will also hear is that it was a deliberate decision taken by the Home Office when it introduced the adults at risk policy to rebalance the policy away from release and in favour of immigration factors. You wouldn't have picked that up from what ministers said. They agreed with Mr. Shaw that it was necessary to reduce the numbers, to improve the safeguards and reduce the numbers of mentally ill people in detention, but instead they adopted a policy that had precisely the opposite consequence. That's important and resonates for a number of reasons. Firstly, because Article 3 of the European Convention on Human Rights sets stringent standards, as well as being absolute and non-derogable, they're also non-delegable. These are not duties that can be subcontracted out. They will always remain with the Home Office when there is failure. And that's because Article 3 requires not only prohibition and punishment of ill treatment, it must also forestall its occurrence. It is not acceptable to intervene only after infliction, when moral and physical integrity has been irredeemably harmed. States are bound to put in place measures that preempt perpetration of ill treatment. Therefore, states must take steps to prevent actual breaches and potential breaches of the prohibition against torture and inhuman and degrading treatment. Those negative and positive duties are critically important when one is concerned with a cohort of especially vulnerable people, those held in detention, and in particular those with mental health. The state's obligation is to take preventative measures to preserve human dignity, and those fundamental failures of the policy and the rules are those measures that this state takes to give effect to those positive obligations, and when they fail, it has serious consequences. It in itself is a breach of Article 3 of the European Convention on Human Rights, and it has catastrophic, as we've seen, consequences for many of those that are held within that framework. We do say that the inquiry needs to look carefully at the forms of ill treatment that are covered by Article 3. The chair to the inquiry opened on inhuman and degrading treatment, but we do say that in the context of the case of D1527, this inquiry must look very closely at whether what in fact he was subjected to was torture. Torture is deliberate inhuman treatment, causing very serious and cruel suffering. It must be inflicted for a purpose, for example, punishment, intimidation, or discrimination. It need not be physical, it can be psychological. A single incident can amount to torture if it's serious and cruel enough. And the threat of physical torture, the threat to kill that we saw so horrifically on the footage yesterday, can amount to mental torture depending on the severity of the pressure exerted and the intention of the mental suffering caused. By contrast, inhuman treatment does not need to be deliberate or intended to cause suffering, and there is no requirement that suffering be inflicted for a purpose. When one looks at the single incident on the 25th of April concerning D1527, we say that it clearly does have the hallmarks of torture: deliberate, intentional throttling or strangulation, application of extreme pressure, and done so in a way that was potentially life-threatening in the context of a menace of a threat to kill, surrounded by verbal abuse and mocking. It seems evident to us that there is a strong case for this being motivated certainly by the fact that this man had mental illness and experienced a disability. We also say from the surrounding evidence that it may well be motivated by discrimination on the grounds of race or religion, or indeed his immigration status. It certainly had as its purpose intimidation. Nobody can be in doubt that the impact on D1572 was cruelty. It caused him the most profound mental suffering. We saw before our eyes what it means when we say to break someone's moral and physical integrity. That howling was the howling of a man whose basic humanity had been stripped from him. And we say this inquiry must give very careful consideration and come to the conclusion that he was subjected not just to inhuman treatment, but also to torture. We say that it is also in that regard significant that it wasn't a one-off isolated incident, although that would be enough. It was part of a targeted pattern of physical mistreatment, abuse and humiliation taking place between April and June 2017. The inquiry must also be mindful of the full scope of what constitutes inhuman and degrading treatment. The key case is the Cudler case, and the threshold is whether or not the treatment caused either actual bodily injury or intense physical or mental suffering. Intense mental suffering, we say, is at the heart of many of the incidents that are the subject of inquiry here. And one has to ask the question, is it suffering and humiliation beyond that inevitable element of suffering or humiliation connected with a given form of legitimate treatment or punishment? We say that in each and every respect, the critical incidents here were very much well beyond any element of suffering or humiliation integral to detention. When one is concerned with mentally ill detainees and the standards that they are entitled to expect, and the state must ensure to avoid inhuman or degrading treatment, the Grand Chamber of the European Court of Human Rights in the case of Roumane and Belgium has given authoritative guidance. It tells us in this inquiry must look at it that suffering which flows from naturally occurring illness, whether physical or mental, may be covered by Article 3 if it risks being exacerbated by conditions of detention for which the authorities can be held responsible. And in assessing that question, one will have to ask whether or not there was appropriate treatment for the physical and medical conditions. One will have to look at the conditions and whether or not those conditions created feelings of fear, anguish and inferiority capable of humiliating and debasing the person. One will have to look at the medical assistance and whether there was a lack of appropriate medical care for persons in custody, because that is capable of engaging the responsibility of the state under Article 3. And it won't be enough simply to have proper treatment, diagnosis by qualified staff. There will need to be a comprehensive record, diagnosis and care which is prompt and accurate. It will require a comprehensive therapeutic strategy to deal with the illness. And it will need to ensure that the person's health problems are not aggravated. All of those matters are important elements of this inquiry. And in each respect, when one has a core participant or other with a significant mental or physical illness, there is clear evidence already flagged up that these obligations under Article 3 have not been met. Whilst, of course, it's always fact-sensitive, this inquiry does have the benefit of 6 decided cases, domestic cases, in which immigration detention without physical deliberate ill treatment have held to cross the line for Article 3, for an Article 3 breach. Those cases are explored in detail in Mr. Shaw's first report. I won't repeat them then. Now, but there were 6. There since has been added a 7th, a man VC, who was held in Brook House in 2015 for a number of months, the Home Office recently conceding that he too was subject to an Article 3 breach. And this is on the basis of these characteristics: a serious mental illness exacerbated by detention, absence of effective medical treatment, inappropriate management through segregation and use of force, self-neglect and compromised interpersonal relations causing humiliation in the eyes of the individual or third parties. We emphasise on behalf of the core participants whom Duncan Lewis represents that whilst of course D1527 was subject to at the very least inhuman and degrading treatment, each of the CPs in their own right equally were too. I give some limited reference to why. Firstly, dealing with D1851, in his entire 3-month period of detention, as you heard from counsel to the inquiry, he was detained unlawfully. He was subject to an assault. Any touching of that man would have been an unlawful trespass to his person. He experienced humiliation, degradation, and had a profound psychological impact upon him, such that it caused him to suffer mental illness in circumstances where he had no pre-existing mental illness. He experienced demeaning language, witnessed disturbed people and disturbing incidents of violence, drug use, distress, and chaos. All of this eroded his mental well-being. It denied his human dignity and undermined his self-confidence, his sense of worth. It changed him, and it broke his moral integrity. D2077 is an Iranian Christian. He was is now a recognized refugee who fled Iran after torture on multiple occasions owing to his faith. He was detained in Brook House for a short period in April 2017, but he'd been previously detained and been released following a Rule 35 report that confirmed that he was a victim of torture. Nevertheless, he found himself again detained, this time in Brook House, despite suffering a major depressive order and PTSD. His despair and distress at being back in detention and in reaction to the conditions at Brook House caused him to stitch his lips together in protest, and he went on hunger strike. D1914, we heard about him from counsel to an inquiry. We saw his Rule 35 report that documented a serious heart complaint. That alone would have been of concern, that despite the Rule 35(1), he remained, he was detained. But in addition to that, there is compelling evidence relating to his experience of severe mental illness that caused him to subject himself to the most horrific self-harm. In that context, he was subject to control and restraint to effect his removal, despite the fact that that alone could have caused him to lose his life. You heard the reference to the disregard with which his medical conditions were treated. If he dies, he dies. He was subject to segregation and constant watch for repeated periods of time. Those factors, segregation, use of force on a severely mentally ill man who also had a serious heart condition, we say readily crosses the threshold for inhuman or degrading treatment. Those are the snapshots. In themselves, they're harrowing. They make the task of this inquiry so critically important. We know that its primary task, and in this phase, is to find the full facts, to identify the culpable and the discredited conduct. And of course, it is to ensure that dangerous practices and procedures, of which we can see already, there are very many here, are rectified. The lessons learned function is critical. It's also important, as Mrs. Justice May identified, that this inquiry provides an opportunity for those who have been subject to abuse to challenge and confront those responsible, to put them on an equal footing, to restore dignity in doing so. We are therefore concerned that the inquiry, as we anticipated, has not had full cooperation, and we do urge, where appropriate, for this chair to use its statutory powers of compulsion so that those who are culpable and need to answer for their actions do so. We also ask that the inquiry consider ensuring that it has witnesses from the Home Office who were present and responsible during the period of time that this inquiry covers. At the moment, we've seen nobody who held responsibility being requested to give evidence. That may change and we may not know the full picture. But at the very least, we asked the inquiry many months ago to consider requesting evidence from Hugh Ind, who was the Director of Detention Services, and his assistant, Mr. Schonenberger, who have been in the Home Office for many years and were responsible for key policies, just like Mr. Ian Cheeseman and Mr. Simon Barrett, responsible for over a decade for the Rule 34-35 policy. We say that these individuals must be called to give account of how this came to happen. Similarly, Home Office officials on the ground in the detention centre, like Mr. Gasson, who was the manager at Brook House, need to be questioned about their responsibility and what they knew. These are all critical parts of the restorative function that this inquiry has to fulfil. It is, in many respects, an historic opportunity for dysfunction that has been present in this system for many years, first and foremost to be explained and exposed, but critically to ensure that it comes to an end. This inquiry isn't the first. You will be aware that Mr. Shaw conducted a report into racism and abuse in 2004, where he found that it was a small number of individuals. In 2005, his second investigation into Oakington identified what he called a subculture of individuals who subjected detainees to abuse and to racism. But since then, we've also had the coroner's report into the death of Mr. Mabenga that exposed racism as a potential pervasive aspect of the treatment of detainees facing removal in 2015, and most recently the Windrush investigation reporting in 2020 and exposing institutional failure and, at the very least, dehumanization in respect of British citizens of black or Asian origin. Those are all important building blocks and starting points for this inquiry when one comes to identify why and the causes, and therefore the resolutions. Mr. Shaw said that he was tired of conducting such investigations, and he's recognised that those inquiries did not solve the problem. That means that this inquiry must do something different to the ones that have gone before. And we say, when one looks at the evidence that has so far been provided by the Home Office from Mr. Riley, that certainly one can see that the Home Office hasn't begun to understand either the gravity of the abuse that was taking place, and more particularly, its responsibility for it. When one reads that witness statement, we respectfully suggest that it's little more than a press release. It's a whitewash, and its value is only in revealing uncontrovertibly that the Home Office does not and has not yet begun to seriously engage in either the evidence, nor to reflect upon what lessons need to be learnt. You are presented with two alternatives. If you go with the analysis of the Home Office, it was a small aberrant group of individuals who were allowed to conduct this kind of abuse because of poor performance management. However, if you look at the reality of the material and take on board the evidence of Reverend Nathan Ward, backed by Professor Bosworth, there is only one answer here. There are fundamental, institutional, widespread problems. They've been given a name as based on dehumanization, discrimination, racism, and xenophobia, and they do infuse the system failure that is exposed by the evidence. It's in that context that we do ask the inquiry, in taking stock and looking at the whole, to adopt the approach that that Professor Bosworth proposes, which is to consider now whether or not actually the only answer, the inevitable answer from all the information that you're going to read, is not a page and pages of recommendation, but saying clearly that this form of power should be reviewed and it should be very substantially curtailed. that can be done through time limits. It can also be done by restricting groups to very limited periods of time in which this power can be exercised. And you will hear, no doubt, in much greater detail in the second phase, what those time limits should be. But the critical task for the inquiry is really to address the bold, but we say inevitable, proposals that were made by Professor Bosworth of actually bringing this power to an end or very severely curtailing it. We know from the Council to the Inquiry that you will also build on the Lampard investigation. We emphasise what she said about the culture of menace towards detainees and a conspiracy of silence and misrepresentation concerning incidents of violence or neglect and the turning of a blind eye. We also point you to the fact that Kate Lampard said that detention at Brook House should be limited to no more than a few weeks. And we remind you that the Home Affairs Select Committee, again, in many respects, found the Home Office culpable for the abuse at Brook House and identified widespread and serious failures in leadership, management and organisational culture. It concluded serious systemic failure. We also say, because 4 years later we have to look at what the position is now, that this inquiry should look very carefully and urgently at the most recent IMB report into Brook House, because on the 2nd of October 2020, it, as I understand it for the first time, issued a notice to the Immigration Minister under Rules 6, 1, 3 and 5 of the detention centre rules, because it was concerned and had come to the conclusion that the regime operated during the removal on charter flights in October 2020 had created a situation collectively and cumulatively whereby those impacts constituted inhumane treatment in the entire centre. In its subsequent report, issued in May 2021, it set out in frightening detail what it was that had led it to conclude that Brook House was once again operating systemically in an inhumane way. And it is frighteningly consistent with what the evidence shows about 2017. High numbers of highly vulnerable people, self-harming, suicidal, being subjected to force to manage their mental health and to remove them from the United Kingdom. And it is a chilling element of that aspect of that report that the IMB identified that the prevalence of the use of force had doubled between 2019 and 2018. And it was increasingly concerned about the prevalence of the use of force. That will obviously be something this inquiry will have to consider in detail when it comes to lessons learned. But we say that its need to identify lessons learned is as critical and as urgent as it was on the 5th of September 2017. We offer then, for the inquiry's consideration, on the basis of the individual cases and the analysis of the material that we've seen, explanation for why this occurred. We say that it is a combination of factors. They're multiple and they intersect, but they do start, and this inquiry cannot ignore, from the demonising political rhetoric concerning immigration, asylum and foreign criminals, which, as Nathan Ward explains, infused the attitudes of the staff on the ground. The policies of hostility are incompatible with humanity. Stephen Shaw himself recognised that in 2005 in his report into mistreatment and racism at Oakington. He said this: the combination of coercive powers over foreigners involved in immigration enforcement with the attitude towards asylum seekers and other would-be immigrants of some sections of the media can become a breeding ground for racist and abusive word and deed. That too was echoed by Lingford Crawford, who gave OBE, who gave a commentary to Mr. Shaw's report, and he referred as significant: the current climate is one of intolerance. We know and we cannot ignore that that climate of intolerance is not generated just by sections of the media or the population, but is led front and centre by the government. And those words and deeds of those in high office impact upon, in critical ways, the context and the attitudes of those at the sharp end in detention centres. We say it's critically, it is an important factor that Brook House was the centre, as it still is, for charter flights and the focal point for effecting removals. It's that put huge pressure on the IRC. Mr. Ward explains how the then director emphasised the high profile and high cost operations for the Home Office of charter flights. And we will see and hear evidence of how that target-driven, removal-focused culture drove many of the practices that exposed individuals to the treatment that is of concern. Like the counsel to the inquiry, we say that you do have to look at the design and the contract. The building was designed to be prison-like, and its regime that was operated was one that was prison-like. It was focused on high security, irrespective of the nature of the individuals who were detained within it. And its systems of control and restraint were focused on refractory detainees with a history of criminal conviction or experience in the prison. But nevertheless, the same techniques and methods were used to the non-refractory, the compliant, and indeed the highly vulnerable. We don't adopt the suggestion that housing those with a criminal history and others is the problem. We say that within the cohort of those who have committed criminal offences are sometimes some of the most vulnerable. It's notable that 4 of the 7 ECHR cases were people with criminal convictions. But it is a critical part of the problems that arose, that this was a regime and an environment that was designed to be for those who present challenges and disruption, and it was used pervasively and arbitrarily on anyone, and in many other situations where it was unnecessary. It's also important to look at the contract, because the material that we've provided to the inquiry, annexed to the witness statement of Mr. Ward, makes clear that this was always a contract that was based on removals and enforcement priorities at the expense of welfare. It was a contract agreed by the Home Office with G4S that came in 35% under budget, but it did so because it provided harsh prison-like lockdown regimes, inadequate activities, and critically low staff numbers. Senior Home Office officials described it as a desperate attempt to reduce costs at the expense of welfare and an ethos of cutting corners, meeting and failing to meet basic standards. Nevertheless, it was awarded to G4S, hardwiring in many of the problems that we see. And it is the context in which the culture of dehumanization occurred. The existence within the detention centre of high levels of mental distress and illness is a critical component of the failure of the abuse. It has a number of effects. It's key to understanding dehumanization and the us and them mentality. Individuals ill-equipped to deal with such complex needs are being asked to care for them, and their response is simply to withdraw and instead to treat the individual and their mental health problems as occasion for the use of force and refraction. We've seen already how abusive and degrading language was pervasive, and we've also seen material that indicates that institutional racism is a real question here. You were referred to the footage of Mr. Connolly advising Callum Tully and using the racist expletive nigger. He was a man in a leadership position. He was described as an expert, and it's clear we suggest that there is a wider culture of racism and xenophobia. Sir William Macpherson identified key aspects of institutional racism in his report into the death of Stephen Lawrence. He described it as the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behaviour which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racist stereotyping, which disadvantages minority ethnic people. The factors that were identified by the Lawrence inquiry as giving rise to institutional racism were the lack of urgency in investigating the incident and failing to see the relationship with race, evidence of negative stereotyping of racial groups by staff fostered through workplace culture, underreporting to the organisation by black and ethnic minority individuals due to a perception that their cases would not be taken seriously, the lack of training and the failure of the organisation to unequivocally recognise, acknowledge and accept the problem, the use of racially insensitive language and terms by officers or staff without understanding as how such language would be offensive. We say that each one of those factors, although they're not a checklist, and more can be added, are in place, and in this regard, the evidence of Mr. Riley will be critical. That culture of dehumanisation and racism is compounded by what we say the evidence shows of a culture of impunity. And it is in that context we say that responsibility falls with senior directors and Home Office officials at the highest level. And it's why when one has a culture of impunity, that oversight mechanisms, important though they are simply not going to be enough. There is evidence that the IMB itself became compromised by the us and them culture, and it came down in favour of the us rather than the individuals its role was intended to protect. Whilst of course the HMI has a professional, independent and effective track record of identifying issues, it failed to do so. And we point to the fact that one of the consistent responses of the Home Office to the HMI recommendations, particularly on the prison-like environment, the excessive lockdowns, the unacceptable conditions, and the lack of privacy in the arrangements in the cells, was consistently ignored and rejected by the Home Office. if the HMI is going to have a better role at regulating and monitoring these facilities, there needs to be some mandatory requirement in the Home Office accepting its recommendations. That culture of impunity is also illustrated by the fact that whilst this is one of the most heavily litigated areas, there are frequent findings by High Court judges and others that the Home Office has unlawfully detained individuals, that the policy is operated systemically unlawfully, as well as in individual cases. But nevertheless, it does not lead to remedial action. It does not lead, as far as we are aware, to any consequential disciplinary action or being held to account for the official responsible, either at an operation or policy level, despite the most serious and significant findings that have frequently been made by the court. Courts, this is a grievance that D1851 has, and it is a reason for why he wished to give evidence to the inquiry. Whatever those mechanisms are, however, this inquiry would need to be satisfied that that entrenched culture of impunity has been addressed, because without it, whatever form scrutiny takes, whether legal or monitoring or overview, will not, as we have seen, address the underlying problems. That then brings me to what actions have been taken. And again, this is going to be critically important for the second phase. But we should make it clear now that on the evidence that we have seen, there is no clear evidence at all that steps have been taken that even begin to understand and identify what went wrong here. It is notable that the Home Office did not end as promptly and as quickly as it could the G4S contract, but instead let it run and even extended it. G4S were in charge of healthcare in Brook House until August 2020. We have not seen any changes of management structures within the Home Office, and similarly within G4S. Critically, there has been no improvement or change to the Rule 34 and 35 process, and there has been no reform, although it's regularly called for, of the adults at risk policy. Whilst DSOs have been issued, the ACDT practices and segregation practices and the use of force within the detention facilities continue as they always have done. Use of force continues to be made and modelled on a prison model. It's inappropriate for the immigration detention context, and it's particularly inappropriate for those who are vulnerable by reason of mental illness. It requires fundamental and radical review. None of that has taken place. It's business as usual since 2017. It's why we say that all those factors, institutional and widespread, have yet even begun to be seriously considered or addressed by those responsible for doing so. It will be the litmus test of this inquiry, what recommendations it makes. We do propose this, what on one hand is the simpler proposition. It is to adopt what Professor Bosworth has said in her report to the inquiry at paragraph 2.28, and seriously now give consideration to alternatives to detention. It is only that, we say, that will meet the challenge of ensuring that what happened at Brook House in 2017 isn't happening now and doesn't happen again in the future. This inquiry must say in particular that for those with vulnerability, detention should not occur. At the very least, Brook House should be operated as it was contractually intended to, for keeping those in detention for no longer than 72 hours. At least in that facility. Only strict time limits and restrictions on this draconian power can ensure that dignity and humanity are protected. We say that should be the outcome and the conclusions of this inquiry, and will provide in this and in its second phase evidence to support that conclusion. That is a convenient time for the break.
That's fine, thank you, Ms Harrison. So we will reconvene in, let's say 11:30, 15 minutes. Thank you very much. Thank you. Mr. Goodman?
Chair, D1527 has been watching this inquiry on YouTube, and I hope he'll be listening to this introductory part of the opening, but I understand he may wish to turn off when it comes to details of his case, and I'll give a warning when we get there. For those less acquainted with the ciphers, we've already seen some of the footage related to D1527. He's the person whose case in the High Court compelled this inquiry to take place. There are three basic reasons why D1527, and indeed all of us, are in this inquiry today. The first is a tragic one. It is that while D1527 was detained in Brook House between the 4th of April 2017 and the 15th of June 2017, he was subjected to treatment that was degrading, to treatment that was inhuman, and he was subjected to torture. That mistreatment must be investigated, because even one case of such behaviour is contrary to the most fundamental norms of a democratic society, but all the more it must be investigated because his experience was not an isolated one. The second reason D1527 and all of us here are here today is courage. D1527 has had the courage to stay with legal processes of forcing the state to investigate and to hold to account those who are responsible for his mistreatment for well over 4 years. That has involved a judicial review to compel his release from detention, a 2-year judicial review to compel this inquiry to be held, a judicial review to compel the Home Office to give him leave to remain, a civil claim for damages stayed behind this inquiry, a judicial review of the composition of the inquiry team, a complaint to the Professional Standards Unit and the Prison and Probation Ombudsman, a police investigation, a threatened judicial review of the Crown Prosecution Service failure to prosecute the perpetrators of his abuse. He is born with these processes in formidably difficult personal circumstances. The inquiry should be in no doubt as to how hard it has been for D1527. We applaud his fortitude. We express in turn D1527's hope that this inquiry will be courageous and take what Professor Bosworth described at paragraph 2.27 of her report as this opportunity for a bold response. We also commend the bravery of Callum Tully and the personal risks he took to bring to light some of the darkest corners of our society. And the third reason we are here is a hopeful one. It is because our law says that no one shall be subjected to inhuman or degrading treatment or punishment, or indeed to torture. And that where such mistreatment does occur, it must be investigated, the full facts must be brought to light, and lessons must be learned so that it never happens again. While the law and this inquiry cannot undo what went wrong, they can restore some of the dignity that was lost. They can ensure that those who wronged D1527 are confronted, and they can ensure that the mistreatment of D1527 is examined, its causes diagnosed, and its cures are prescribed. So I'm going to take the inquiry very summarily through some of the horrors that MA endured in detention. There are 4 points to emphasise at the outset. The first is that almost all of what happened to D1527 could and would have been avoided if the legal requirements of the Detention Centre Rules 2001, particularly Rule 34, and the Adults at Risk policy had been observed. If the Home Office had operated the immigration detention system as it is legally required to do, then D1527 would have been medically examined, and a report identifying him as a suicide risk and torture victim would have made its way to the Secretary of State within a day of him being detained, and the Secretary of State, if she had properly applied her policies, would have released him. It is the outlawry of the Home Office and its contractors that allowed the events with which we are concerned to happen. Second and related, the Home Office had every chance to avoid what happened to D1527. There were literally dozens of occasions when the failures of the Home Office to comply with the law, particularly Rules 34 and 35 of the Detention Centre Rules and Article 3 of the European Convention, had been emphasised by the courts, both in individual cases and on a systemic level. A chronology of these events will be submitted shortly to the inquiry. Third, it must be emphasised that the inquiry's Article 3 investigative duty must extend to consideration of the cumulative effect on D1527 of the whole of what happened to him. Even leaving aside the incidents of physical abuse and mistreatment, D1527's treatment as a whole throughout detention was inhuman and degrading. That is obvious having regard to the 6 cases in the High Court and Court of Appeal between 2014 and 2016, in which it was found the Home Office's practices in immigration detention breached Article 3. They had all been about the way in which mentally ill detainees are treated. And fourth, the inquiry is invited to find that the incident which we saw on video on the 25th of April constituted not just inhuman and degrading treatment, but torture. I turn then to an outline of what happened. At this point, if my client doesn't wish to hear this recounted, he may wish to turn off. D1527 suffered many horrors, including torture in his country of origin as a child, and then yet more horrors and abuse as he made his way to this country across the Mediterranean as an unaccompanied child. The details are set out in the accounts given to the doctors, Dr. Thomas, which is HOM 002997, and Dr. Bazu, CPS 000011, paragraph 512. Before he was detained in Brook House, D1527 had a history of mental health problems, including having been hospitalised after a suicide attempt. Immediately before he was detained by the Secretary of State, he had been held on remand in HMP Belmarsh, which was also a very difficult experience for him. The National Offender Management Service had undertaken an assessment which recognised him as a vulnerable young man. At the time, he was 17 years old, by his account, though he was deemed to be 19 by the Home Office. NOMS assessed the likelihood of his reoffending as low. When the charges came to trial, he was advised to plead guilty to 2 minor offences because his lawyers foresaw he would not receive a custodial sentence. He duly pleaded as advised, and on the 9th of March 2017 was sentenced to a community punishment, and he believed he would be released from HMP Belmarsh at that moment. However, instead, the Secretary of State directed he should remain in prison, detained indefinitely under immigration powers. D1527 fell into despair. He found the experience very difficult to deal with, and his solicitors advocated to the Secretary of State that he should be transferred from prison to what should have been the more relaxed regime of an immigration removal centre. After 4 weeks in Belmarsh, he was transferred to Brook House. It would appear late at night on the 4th of April, treated as the 5th in some of the admission documentation. Now at this point, Rules 33, 34 and 35 of the detention centre rules came into play. We've already heard a lot about Rule 35.3 of the detention centre rules, the duty to report on victims of torture, and we've seen Dr. Hard's report referred to, which goes into more detail. Here I want to emphasise Rule 34 of the detention centre rules and some of the other subparagraphs of Rule 35, 35.2 and 35.4, and shortly I'll talk about Rule 45 as well. And I've sent in a summary of the rules. They're appended to the hard copies of the opening statement. If we could bring those rules up on the screen. Rule 34.1 required that upon D1527 entering Brook House, within 24 hours he should have been examined by a medical practitioner, which means, in relation to IRCs, a person who is vocationally trained as a general practitioner and fully registered within the meaning of the Medical Act 1983.
Mr. Goodman, sorry to interrupt you. Did you want to try to get the document
If it could be done,
onto the screen?
that would be helpful. If we get the detention centre rules up. They are appended at the back of the hard copy, Chair, if it's easier to look there while we get that up.
We may not be able to do that if it's not uploaded for the document handler at this point.
It's been sent through to the document handler, but if it can't be found, we'll crack on.
Do you want to continue and
I'll
we'll
crack
try and
on
get those up
and
if we
hopefully
can?
we'll get it up as I'm talking.
Okay, thank you.
The important point is Rule 34.1, Chair, and that required that within 24 hours of admission to Brook House, he should have been examined by a general practitioner. Now, given that upon transfer to Brook House, D1527 was already on ACCT, Suicide Watch from Belmarsh, and see the references here, CJS 001073, CJS 001035, and SXP 000125, What should, according to the law, have happened then was as follows. 1, a physical and mental examination within 24 hours, that's Rule 34.1. 2, a report by a general practitioner to the manager on D1527 suicidality, that's Rule 35.2. In fact, had an examination been undertaken, a report would also have been required under Rule 35.3 in his case. He's a torture victim. 3, a report by the manager to the Secretary of State, Rule 35.4. And 4, consideration by the Secretary of State applying the criteria in the adults at risk policy of whether to maintain detention in light of the GP's assessment of his suicide risk, his history of torture, the likely duration of detention, and all other factors. That legal requirement that there be a physical and mental examination within 24 hours has applied to the detention of every detainee in detention centres over the past 20 years. An examination of the litigation history and of the various independent reports of people such as Stephen Shaw will show the inquiry that the Home Office has repeatedly failed to enforce it, and that its contractors have more often than not been blind to its existence. Although a physical and mental medical examination by a GP should have been automatic on admission, aware that the Home Office has never regarded that law as a priority, D1527's solicitors wrote to the Secretary of State on the 5th of April, the day 1527 was admitted to Brook House, requesting there be such a medical examination under the detention centre rules. That's HOM 001_005. Yet despite the Rule 34 obligation, despite the correspondence from D1527 solicitors, and despite, even more alarmingly, the fact that when D1527 arrived in detention he was on suicide and self-harm watch, see CJS 000961, inquiry document. Despite all of that, D1527's physical and mental health was not examined by a medical practitioner within 24 hours, or at all. On the contrary, the Secretary of State, apparently in complete ignorance of her legal duties, wrote back to D1527 solicitors on the 5th of April, turning down the entreaty to conduct a medical examination. That's reference HOM 000101_002, and telling them that the onus was on the client to raise any concerns he had with staff at the detention centre. That notion seems to have been an enduring one because it was an argument made by the Home Office in the 2006 case before Mr Justice Davis of HK Turkey, 2006 CWHC 980 admin at paragraph 53, and rejected there. The very next day, the 6th of April, the solicitors wrote again. This is HOM 000345, pointing out to the Secretary of State her obligations under the Adults at Risk policy and enclosing a report from a psychotherapist who had previously treated D1527 in the community, and which explained that D1527 was a very vulnerable young man, immensely troubled by mental health issues. And the reference is HOM 000345_006/7. His solicitors again requested that a medical assessment be undertaken of D1527's vulnerability. Still no examination was undertaken, and on that day, 6th of April, the Secretary of State reviewed the detention of D1527, that's reference HOM 000572, and it was decided to maintain detention. In taking that decision, no proper consideration was given to the evidence of his vulnerability, his mental health issues, his suicidality, or his history of torture. The legal safeguards under Rules 33 to 35 of the detention centre rules were designed to ensure that the suicidal, the mentally ill, and the victims of torture should not ordinarily be detained. They were ignored. There is no suggestion in the files that their full effect was even understood by the medical staff or the Secretary of State. And thereafter, in the 3 months that D1527 was detained, and despite multiple suicide attempts and many periods on suicide watch, the Rule 35.2 and 35.4 process was never fulfilled. In fact, we know that in 2017 as a whole, there were only 10 reports pursuant to Rule 35.2 across the whole detention estate, see IS Bangladesh at paragraph 194, and the Freedom of Information requests referred to therein. Furthermore, there was not a single Rule 35.2 report at Brook House in 2017, and indeed right up to 2021. See the Annex 12 to Nathan Ward's witness statement starts at DL 000140_0156 and specifically up to 2021 at pages 0175 to 180 of that document. Because there was never a GP's report, the manager never wrote to the Secretary of State. The Secretary of State never took any such report into account in deciding to maintain detention, and even when D1527 solicitors engaged an expert to produce a detailed psychiatric report, that was not considered in connection with authorising detention either. Now, I've taken time to spell this out because if the detention centre rules had been observed, along with the requirements of the operating standards and the adults at risk policy, then the likelihood is that, considering D1527's detention against the adults at risk policy, it would have been apparent to the Secretary of State he met the definition of an adult at risk under that statutory guidance. He would not have been detained beyond an initial 48-hour period, 24 hours to examine him and 24 hours to ascertain that he was suicidal and credibly a torture victim. The Secretary of State would have taken that into account and, in all likelihood, applying her policies properly, would have released him. So there's a simple point that if the system had operated in the first 48 hours as Parliament intended when it established the detention centre rules, we would not be here today. However, it may also be said that if at any point during the detention the system had operated as it should, the safeguard of the adults at risk policy and the detention centre rules should have ensured D1527's prompt release. What ensued instead of the release of D1527 is a lesson in why those safeguards, particularly Rule 34.1, were prescribed by Parliament. It's also a lesson in how egregious it is that the Home Office by 2017 had still not secured compliance with the detention centre rules. The Home Office failure to abide by the law has been well known to those working in this field since at least HK Turkey in 2006, well before D1527 was detained. Stephen Shaw's report, in his 2016 report, looked at the Rule 34 and 35 procedures and noted they were intended to be a key safeguard in ensuring that vulnerabilities were identified in detainees, and that it was abundantly clear that Rule 35 was not fit for purpose and was failing to protect vulnerable people who found themselves in detention, in a large part because the Home Office did not have sufficient faith in its own system. One of the 64 recommendations Mr. Shaw made to the Secretary of State to improve the protection of vulnerable detainees was to immediately consider replacing the Rule 35 mechanism and to consider the use of independent doctors in the IRCs. As an aside, it may be observed that the defendant never progressed to a point anywhere near obtaining a travel document to remove D1527, even well after he was released. The whole experience of detention, torture, inhuman and degrading treatment was unrelated to a credible attempt at enforcing immigration control. As the inquiry will be aware, although the statutory function of detention is to facilitate removal, that is not how it is used in most cases. A significant majority of people who are detained are subsequently released rather than removed. What happened next? D1527's history is set out more fully in his witness statement, his Rule 9 response, and in the medical reports on his behalf. There's time only for some highlights of the themes, and that will have to suffice. But a forensic analysis of his case is commended to the inquiry. Medication. First, D1527's psychiatric medication was not brought with him on transfer, and he didn't receive it for 6 days. Self-harm. In the meantime, having arrived at Brook House, he began to self-harm, the first incident on the 9th of April, and the references are CJS 001146 and CJS 000611. He was treated for a cut wrist. See also H0M 000547 and CJS 001049. His self-harm and suicide attempts persisted throughout the detention, Dr. Thomas reporting that by the end of May there were near daily attempts, including banging his head against walls, cutting himself repeatedly, tearing bedding and clothes to make ligatures around his neck. Dr. Basu reports in his report there was no engagement at Brook House with the reasons for self-harm. They simply tried to manage by removing the mechanisms or means available to him for achieving it. food and fluid refusal. In total, at one point, on 33 days out of 38, he refused food. Physical and verbal abuse and victimisation. It's also clear that self-harm was the occasion for abuse by staff, which in turn was the occasion for further self-harm. When detention custody officer Calvin Sanders was on observations and suicide watch and boasted to other officers that he had bent back the fingers of D1527 and banged his head up and down on the bounce, he says it was funny. He says, "You're an attention seeker, you prick." That was while he was on self-harm and suicide watch. The strangulation incident on the 25th of April that we saw yesterday in the hands of DCO Pascali similarly was occasioned by attempts to self-harm with a ligature and to swallow a battery. See the video at V20170425000021. Similarly, in the incident on the 4th of May 2017, where D1527 found himself on the netting, see Kenkov 1012 and V201042500022. He had been refusing food for 5 straight days beforehand and over most of the time since the 19th of April. He says he felt there was no point in eating because there was no hope left for him. The 4th of May 2017 incident was ultimately de-escalated successfully, only for a full team of DCOs to raid the cell in which he was recovering and to drag him forcefully back to E-Wing. We've not been shown the CCTV footage of that incident yet, but we can see that the incident involves the deliberate infliction of pain by officers on D1527. See CJS 005530. According to Dr. Basu, in each case, these incidents exacerbated his suicidality, self-harm and mental health problems. Other features of his detention included double binds. On the 21st of April, nurse Karen Churcher told him, entirely incorrectly, that because he was self-harming, he would stay in Brook House for longer. This is what psychiatrists used to call a double bind, and he describes in his evidence that that made him feel there was no way out. He had no hope, and later that day he tried to kill himself. Suicidality. Dr. Thomas's report, reference HOM 002997, describes how by the time of her visit and assessment on the 20th of May, his suicidality was severe and acute. She advised in her report that in her view the likelihood of a successful attempt in the following 3 months was high to very high. Her opinion was that there was a real possibility of a psychotic breakdown, as indeed D1527 had predicted himself. The report was sent to the Secretary of State on the 31st of May, who paid no heed to it. Detention of torture victims. Following persistence by his solicitors, a Rule 35 report was prepared by Dr. Uzer Ali on the 13th of April under 35.3. He noted that D1527 had tried to kill himself a few weeks prior. He did not regret it, that he repeated his intention to kill himself to mental health nurses, and that he was again on suicide watch. There was still no Rule 35.2 report on his suicidality to the manager, and no Rule 35.4 report to the Secretary of State. Nonetheless, the 35.3 report did accept that he gave a credible account of torture and that he had scarring consistent with his account. The report was sent to the Secretary of State. The Secretary of State looked at it and concluded that D1527's needs could be managed effectively by the healthcare team in detention. That conclusion was based on no clinical assessment. See HOM 000644. There was no psychiatric advice that D1527 was being managed in detention. Quite the contrary. The Secretary of State's assumption that his fragile psychology could be managed was at odds with the whole purpose of the system designed to safeguard torture victims. They are recognised as intrinsically vulnerable to re-traumatisation. That should be the principle underpinning the Secretary of State's statutory adults at risk guidance, but is certainly not applied in that way. Racism and dehumanisation. We've heard evidence about how he was denigrated, denied his right to visit a mosque. When D1527 was subjected to dehumanising insults and treatment, he was sworn at, he was called derogatory names. We've seen references made to him acting like a baby or sucking on a dummy. We witnessed yesterday that after being threatened that he would be put to sleep and throttled by DCO Pascali, he was then demeaned as he fell into a state of terror and panic being called, "You fucking piece of shit," and when he does not stop gasping, he is asked, "Are you a man or a mouse?" We've heard how the detainee said he was treated like an animal. In his own evidence, he says he wasn't believed as to his self-harm. He said it made him feel that no one would take him seriously. They didn't care whether he lived or died. "I felt like animals at a zoo were treated better than I was." The 1527's description resonates with D1713's description of how he was told by a female officer that she would never lock up her dog, but she would lock him up. And some of what we've already seen is redolent of a human zoo. We've seen in the clip where D1527 is self-harming. Just before he's strangled and demeaned, the officers are taking turns to peer in at him through the window to the cell and joke about his predicament with Duracell bunny jibes. We've heard how on the arrival at Brook House, DCO Tully witnessed a bizarre humiliation ritual where a detainee was standing naked as officers and managers stood around laughing. We've seen that when D1527 was on the suicide netting on the 4th of May, in the video yesterday, a large part of the population of the detention centre, staff and detainees alike, stood around watching him undergo a psychotic episode. For many, this was entertainment, and they taunt him, one detainee relentlessly singing, "I believe I can fly," perhaps goading him to jump. Officers are dismissive, laughing at him too, for expressing his feelings. We hear DCO Clayton Fraser laughs at the best way to deal with him is what Jan did, in reference to Pascali's strangulation. This is not so much redolent of a zoo as the Bethlehem lunatic asylum in the 17th century. Removal from association. D1527 says he hated E-Wing. He was frightened of the isolation, the screaming of other detainees, and particularly because it left him more vulnerable to abuse by other officers. Denial of his dignity and religious rights. He was denied the right to go to the mosque, seemingly in Ramadan. He was subjected to excessive and unlawful use of lockdown procedures, as the Hussein case, 2008, EWHC 213 admin confirms. The absence of any fulfilment of duty by any DCO or medical officer. Turning again to the detention centre rules, if we've managed to get those up, or in the appendix to the written note. Rule 45.2 of the detention centre rules imposes a statutory duty on every officer to inform not only the manager, but also the Secretary of State promptly of any abuse or impropriety which comes to his knowledge. There's no evidence that any officer in the employ of G4S has ever fulfilled that duty. They certainly did not in D1527's case. And yet let us recall the Home Office commends G4S. The aftermath. Where a state breaches Article 3, it falls under a duty to do what it can to repair the wrong. It might be thought that where it had been exposed, that in the care of the state and at the hands of a global corporation, that a man has been tortured, that a minister and a chief executive would have knocked on his door to apologise. The Home Office and G4S have been represented by Queen's Counsel over 4 years in relation to this man's case. They have had ample advice. They have chosen their actions. There has been no apology, no attempt to repair the damages. Both organisations knew about Panorama before it aired. Neither contacted D1527 or sought to contact him for the purpose of investigating what had happened. No compensation has been offered. Nobody has owned up to take responsibility. At this inquiry, the Secretary of State and G4S are in attendance through their lawyers. Nobody is here from the Home Department making an effort to learn lessons. Even before this inquiry, the Home Office corporate statement is advanced by Mr. Riley, somebody who had no involvement, has no knowledge of what happened. His line is that D1527's mistreatment was mainly the fault of G4S employees, but that corporately, G4S is apparently to be commended, and its contract was of course extended after these events. The Secretary of State and G4S and the individuals involved in the incidents on film have all been sued for damages. Not one of them has sought to mediate or settle the claims. They have resisted and made D1527 wait. The Secretary of State, for her part, has taken every available point of defence, and where her position has been indefensible, she has delayed. When D1527 brought judicial review proceedings in June 2017 while detained, he was alleging Article 3 breaches even then and seeking to compel his release. The Secretary of State resisted his release in the High Court and argued in court he should be detained longer because she had not yet managed to assimilate the medical report that described daily suicide attempts. When he pursued the claim seeking to compel what has become this investigation, the Secretary of State resisted again. Our actions meant that proceedings in the High Court did not conclude until August 2019, 2 years after Panorama. Even then, this inquiry was not instituted until November 2019, and the inquiry will understand the course of delays since then better, but D1527 does not, and it's not been explained to him. When D1527 asked for leave to remain in the UK, so as to enable him to vindicate his rights, the Secretary of State refused to grant it. D1527 was forced to challenge that position, again by judicial review, and only after the High Court granted permission for his case to proceed did the Secretary of State ultimately concede with the grant of a short period of leave. But that's not been renewed, so now 1527 is currently compelled to subsist on the barest form of leave, by which he is not actually threatened with removal, but which gives him no period of certainty and no up-to-date biometric permit or residence card. The practical effect is he cannot get a job because few employers will take someone without surety they'll be staying here, and when D1527 sought to have his abusers prosecuted, the state failed him again. He lives in a limbo, his life suspended, his psychological fragility incapable of being resolved. Although Panorama is striking and shocking, a full analysis of D1527's case shows that it's not just about the incidents filmed by Mr. Tully. Even if he had not been abused by several different officers on several different occasions, even if he had not been strangled, humiliated as a baby and a mouse, and intimidated with being put to sleep, his experience of detention would constitute inhuman and degrading treatment. The Professional Standards Unit has already found that he was degraded, reflecting the language of Article 3. As to inhuman treatment, he suffered it as a result of the cumulative effects of his vulnerability, the physical and psychological abuse by staff, the conditions of his detention, the lack of adequate medical treatment, particularly for mental illness, the feelings of inferiority, the inability to complain to seek redress, the duration of his detention, and the impact of the conditions on his physical and psychological integrity. All the case law shows that the inquiry must consider these factors in combination in discharging the Article 3 investigative duty. And finally, in relation to torture, I give the definition in the written note. All the components of that definition are satisfied. D1527 suffered severe pain and suffering, both physical and mental. That suffering was intentionally inflicted in the assaults. It intimidated him. I'm going to put you to sleep, you fucking piece of shit. It was based on discrimination against him on grounds of race, nationality, his immigration and detention status, and on grounds of his mental illness. It was inflicted by those acting in official capacities. It is important that this inquiry finds that D1527 was subjected to torture, not to inhuman and degrading treatment alone, but to the intentionally inflicted acts of torture by state agents. It matters because of all the reasons we've given in Ms. Harrison's opening about the purpose of Article 3, rooted as it is deep into the common law. It matters because one of the gravest of constitutional lines has been crossed, and that needs to be said. The courage that D1527 and Mr. Tully have shown presents a challenge to this inquiry to act with courage, to vindicate the truth of what happened, to acknowledge that in D1527's case the most fundamental values of a democratic society were violated. That is the challenge to this inquiry. Thank you, Chair.
Thank you, Mr. Goodman.
Chair, I will address you now in relation to Reverend Nathan Ward. Reverend Ward became employed by G4S in 2001. At the time, the organisation was known as Group 4. His role at the outset was as a part-time chaplain at the Medway Secure Training Centre. He stayed in that role until 2007, and during the course of that work was awarded a National Youth Justice Award. From 2007 to 2011, he worked as an enrichment manager at the same secure training centre, which included being duty director. In 2011, he completed a secondment at Gatwick IRCs, which includes Brook House and Tinsley House, and he was based primarily at that time at Brook House. At first, Reverend Ward had no official role, but he helped to develop the family and safeguarding policies for Tinsley House. He was then seconded to work on business development in children's services for G4S. And around 8 months later, at the end of 2010, he was offered a role involving the redevelopment of the family suite at Tinsley House, following the then Deputy Prime Minister's announcement to end child detention. The family suite was a section of Tinsley House that held families with children prior to their removal from the UK. Then in January 2011, Reverend Ward became head of children's services at Gatwick IRCs. Leading up to 2012, he became the head of Tinsley House as part of the senior management team, or as we've heard it referred to, the SMT for Gatwick IRCs. And he resigned from G4S on Monday, the 14th of April, 2014. And he had this to say about his resignation. Until this point, I had stuck it out because I felt that I could still make a difference to people's lives and help reform from within G4S. It was work that was something of a vocation for me and rooted in my Christian faith of service to disadvantaged, marginalised people. Ultimately, however, after many years of trying to make a change, I felt I just could not cope with continuing to work for G4S. I realised that by remaining in the system, I was perpetuating an unjust, inhumane system, which I would now describe as barbaric. Following his resignation, Reverend Ward visited a psychiatrist who referred him to a psychologist, and he was informed by that psychologist that he had post-traumatic stress disorder, which was due to the trauma he witnessed and experienced whilst working for G4S at Medway Secure Training Centre and also at Gatwick IRCs and in particular Brook House. It's worth addressing you, Chair, in relation to what happened at Medway Secure Training Centre. Whilst there, Reverend Ward had a number of concerns about the treatment that he witnessed the children experiencing, and he became a whistleblower and reported those concerns to a number of individuals. He notes that abuse that was exposed in an undercover panorama programme on Medway Secure Training Centre exposed similarly harrowing evidence with close parallels with what would be exposed a year later at Brook House. Chair, we would invite you to look in particular at the Medway Improvement Board's final report of the board's advice to Secretary of State for Justice. That was a report that looked at the failings at Medway Secure Training Centre and identified a number of them. It's worth noting a number of those failings now, and Chair, we hope that you will see that there are some parallels with the features of Brook House. One of those findings is that there was a lack of clarity on the purpose of a secure training centre. Another finding was that leadership within the secure training centre has driven a culture that appeared to be based on control and contract compliance rather than rehabilitation and safeguarding vulnerable young people. Another finding, significant concerns this culture and emphasis on contract compliance may be leading to reports of falsification of records as seen on Panorama. Another finding, there are blurred lines of accountability and an ambiguous management structure. Another finding, Current safeguarding measures are insufficient and outdated. There is too much emphasis on control and contract compliance and not enough on the best interests and mental well-being of the trainees. That's what they were referred to, the children were referred to at Medway Secure Training Centre. Here we can replace that word with detained people. Another finding, the board is not convinced that the various organisations involved in scrutinising and responding to safeguarding at Medway STC are coordinated in their approach, increasing the risk of safeguarding issues falling through a gap. Another finding, there is a history of similar concerns being raised repeatedly in letters from whistleblowers and former staff. Policies forming part of the STC contract need to be reviewed to ensure that they support the overall safety of young people rather than focus on contractual penalties. Another finding, whistleblowers and children inside of the STC need to have an effective support framework in which they feel safe to raise concerns and complaints. There is a lack of understanding of the causes and drivers of behaviour problems and too much focus on controlling behaviour rather than dealing with underlying vulnerabilities. And the board in that case had concerns about how Youth Justice Board manages their contract and monitors safeguarding at the STC. There is a need for formal separation of the often conflicting YJB monitoring functions of ensuring contractual compliance and monitoring safeguarding. And finally, regardless of who manages Medway STC, changes in culture, leadership, and staff approaches are needed. For these reasons, the improvement plan needs to incorporate effective mechanisms for continuity of improvement, assessment of impact of improvements, and a timetable for handover. And this is what Reverend Ward has to say about that. These findings and the report as a whole present stark similarities to the abuse and corruption exposed in the Panorama documentary on Brook House. It is notable that Interim Director Ben Saunders, who was seconded as Director for Brook House and later returned in 2016, felt the key to the problems lie in organisational culture. Peter Needon, President of G4S UK and Ireland, also commented that there was a need to encourage a change of culture and for people to be able to openly raise their concerns. And what Reverend Ward had to say was, there does not, however, seem to be any reflection on their own responsibility for their organisational culture. Furthermore, Reverend Ward is not aware of whether G4S has done any analysis or undertaken any comparison between the culture at Brook House with that seen at Medway STC. And Reverend Ward's view is that this should be the starting point for this inquiry, the Medway situation and the circumstances there. If lessons are really to be learned, and more importantly, for real change to be brought about. Chair, I'll just provide a few examples of what Reverend Ward witnessed and experienced while working for G4S at Gatwick IRCs. There are many more examples contained within his witness evidence. But these examples demonstrate the diversity of the issues that Reverend Ward witnessed and experienced. Number one, witnessing or being aware of a number of inappropriate uses of force at Brook House. Number two, a culture of racism, including the use of cultural stereotypes and generalizations and clear evidence of an us and them mentality. Number three, healthcare assessments being completed over a short period of time, often upon a detainee's arrival at the centre, sometimes in the middle of the night when someone had been brought in after a traumatising enforcement experience and were unlikely to be in a position to disclose a history of torture, mistreatment, or trauma. And the fourth example, as I said, there are many more, but the fourth example for these purposes, in around 2011 or 2012, Reverend Ward received an email from a G4S accountant with an asset list for CEDA's pre-departure list, asking him to highlight items that were charged to the Home Office, but that G4S would never actually buy. Chair, 4 diverse examples of the concerns that Reverend Ward had. As I said, there are many more. It's also worth referring to the question of the use of force and Reverend Ward's experience of that. And this is the way in which he describes assaults and abuse as shown on Panorama as a gross manifestation of an institutional, corrupt and toxic culture, the same culture that he witnessed and experienced while working at Gatwick IRCs at Brook House. And this is what he says about that. Whilst the footage inevitably focuses on a core group of staff, in my experience, it is likely the behaviour of staff was perpetuated by the system in which they were working. It represents a system in which members of staff felt confident enough to take this action and even cover up outrageous abuse without repercussion. I do not believe from my knowledge that they could have conducted themselves in this way without the wider institutional culture of dehumanization and othering that was at play, which made this conduct accepted by many more staff. And Reverend Ward will give evidence of a toxic, masculine and bullish culture. And this same toxic culture was also a feature of the training on control and restraint. And Reverend Ward had this to say about the training. I witnessed staff being trained in degrading ways, such as forcing them to dress up in boiler suits and helmets to do warm-ups, with press-ups if they made mistakes. I witnessed the visible adrenaline of staff who would regularly engage in control and restraint following the restraint. They seemingly enjoyed the adrenaline rush, and it was reflective of the alpha male attitude. Reverend Ward again became a whistleblower. He raised his concerns with a number of people. He raised his concerns with Deputy Director Duncan Partridge. He raised his concerns with Director Ben Saunders. He raised his concerns with Home Office Monitor at Tinsley House, Deborah Weston. He raised concerns with Regional HR Manager Steph Phillips. He raised concerns with Managing Director Jerry Peverick. He raised concerns with Kent Police, and he was told that they had shared those concerns with Sussex Police and the Serious Fraud Office. And he raised concerns with the Home Affairs Select Committee. And yet, there have been no criminal prosecutions arising from the events at Brook House. As Reverend Ward states at paragraph 308 of his statement, his first statement, this is a major accountability deficit that impacts on people's trust and confidence in the system. And it is the lack of accountability and sanctions to date that is Reverend Ward's primary reason for participating in this inquiry and why he considers it important. He's not motivated by money, he's not motivated by status, and he has nothing to gain personally from bringing his concerns to light. And in fact, as you've heard, Chair, it's had a negative impact on him. This is what Reverend Ward has to say about his participation in this inquiry. I strongly believe that things will not fundamentally change unless people are held to account at all levels of the system, and serious consequences occur for the individuals and corporate bodies. I do not understand how G4S could continue being the contract provider for almost 3 years after the Panorama broadcast, which included a 2-year extension, and equally why any contract could continue to be run with G4S after the Medway and Brook House reporting. I also do not understand how managers within G4S with oversight for these centres or on site, like Ben Saunders, Steve Skitt, Jules Williams, or Steve Dix, were not dismissed, but were able to continue in their roles or take up posts elsewhere. I also do not understand how senior civil servants responsible for these contracts, such as Paul Gasson or Mr. Schonenberger, and for detention services generally, have not been disciplined but remained in post. And he finishes with this. Until concerted action is taken and is seen to be taken, complaints made will be ignored or more likely won't be made at all because people will have no confidence in the system. So in summary, Chair, what Reverend Ward wants to see is real state accountability, real corporate accountability, real action and real change. Thank you.
Thank you, Ms Morris.
Good afternoon, Chair. Forgive us dealing with the mechanics of this. I hope also that a message has got through to you that we were adjusting the order of the speeches. I have an hour. What I propose to do is get just shy of half of that done before the lunch break, if that suits
sounds
you.
perfect, yes.
Great.
Thank you, Mr Armstrong.
Chair, I appear also with Ms Morris representing and instructed by Dayton Pearce Glynn solicitors, 3 core participants in this inquiry. They are D687, D390 and the charity Gatwick Detainee Welfare Group, will be known throughout as GDWG. Can I just be clear that both D687 and D390 have been present throughout the last 3 days and are present now. They are listening intently to all that is being said. That is, of course, very often not easy listening for them, and it is not easy watching, particularly through D687's video that was played yesterday. But they do that because it is something that they want to do. They want to listen, they want to contribute in order to understand to the extent that they can what happened to them and to assist you as best they can as being as effective as this inquiry can be. Can I also just say this? I have circulated a paper, and I know that you've got the paper. I am going to speak to that paper. I'm not going to do all of it. I don't have the time to do all of that. But I do ask that the original paper be formally adopted for the purposes of this, and the documents to which it refers be formally adopted, and we will sort out the mechanics between your team and ours, hopefully overnight. But if anybody else wants a copy of that paper, we can circulate it directly too. I start my opening by referencing a point that's been made by others already, but is that there is something uniquely toxic about immigration detention. And we say that that toxicity arises because of the scale of the power imbalance that is in play here. There is a power imbalance in any detention context, as I know, Chair, that you will know, but it's particularly pronounced in this context because of the scale of the immigration detention power, which is often unpredictable and often indefinite in its application. That's on one side of the balance. On the other side of the balance, you have the particular nature of the immigration detention cohort, who have a particular range of vulnerabilities, which we say puts them at particular risk of abuses of power. Now, ensuring that those abuses don't occur requires particularly robust systems and safeguards. It requires eternal anxious oversight, and we say that a system that's calibrated for immigration throughput, if I can put it that way, rather than welfare, that is managed at the lowest possible cost and which leaves junior and inexperienced staff operating without leadership guidance or proper oversight, is not that system. And we, like others that you've heard from this morning, support what Professor Bosworth says about this. She is not alone in thinking that the only solution to this may be a time limit. As she says, that may be the only way to reduce the kinds of distress shown in the BBC footage and to foster the appropriate professional staff culture. We also, the DPG core participants, support that, and they support also her invitation to be bold. They also say, unsurprisingly, it is now very clear that mentally ill people should simply not be detained under immigration powers. Chair, it won't surprise you to learn also that we invite you to accept what Professor Bosworth says and seize the unique opportunity to do something about these matters. Nothing like this inquiry has ever happened in the immigration detention context before. It was very hard to bring the inquiry about. D5127 and D687 did have to take a 2-year judicial review in order to achieve that. And given that, it may be thought that nothing like this will ever happen again. So you may have the one and only opportunity to do something about what we are seeing in these proceedings. Now, just developing that point about the nature of the cohort a little, and talk about the characteristics which that cohort have. I've set this out in the paper, and a lot of it will already be familiar to you, so I'm just going to draw out some particular points, if I may. It starts with the prevalence of mental ill health, but can I just emphasise that that doesn't necessarily mean people who've already had a formal diagnosis of mental ill health. It may be that people have mental ill health that is only just emerging, and that may well be because this cohort often comes from particularly traumatic backgrounds. They may be fleeing persecution, and they may have the kind of trauma that is likely to be exacerbated in a detention environment and suffer re-traumatisation. And I mentioned that D390 in particular may be an example of this. He had little in the way of a formal diagnosis at the time that he arrived, but he had a background of childhood trauma and some recent time in prison for documents offences, for immigration documents offences. But the point is this: none of this is surprising or unpredictable. The Home Office and G4S know very well from the history, from the cases with which they've been involved and from the studies that have been done in this area, that this is true of this cohort, and that they this is what they can see happening, and they are under an obligation, a responsibility to ensure that their systems are alert and responsive to such things and are there to respond to mental health presentations as they emerge. Mental health obviously links to things like suicide and self-harm, although the overlap is not a complete one. The suicide and self-harm in immigration detention is a reflection of the despair and the absence of hope that many feel. It is unfortunately self-harm in particular may afford many in immigration detention the only control over their lives which they feel able to exert. And you can see that very clearly again in that footage that we saw of D687 yesterday on the 13th of May, which is such a painful watch for anybody. And can I just, while I talk about suicide and self-harm, just put down a marker in relation to a particular point, and Mr. Goodman referred to it in his opening just a moment ago, which is that there is a real issue between this divergence between the number of ACDTs in the system and the very small number of Rule 35.2 reports. And he has referred to the case of IS Bangladesh, and I've put the reference to that in the paper as well. There is a real system problem with this, and it may be as follows, which is that the ACDT system is drawn from the ACCT system, which is the prison system, and I suspect, Chair, you are all too familiar with the ACCT system from the prisons. But there is a difference between immigration detention and prison. There are many, but this one matters for present purposes, which is that in prison you do not have an administrative detention power in play. You do not have the possibility of release if somebody, for example, is deteriorating. And that means that the ACCT system is not designed by reference to linking to the detention power. There is no need to link ACCT to a release valve because there isn't one in the prison context. There is a need, however, to do it here, and it is supposed to be the 35.2 system, but there appears to be no link drawn. There is not, for example, on the ACDT documents, a prompt to say, in an ACDT review, for example, is this somebody who needs a 35.2 report? It appears to be a system design problem. It may be a carryover from how the system was originally designed. I've then talked in the paper about things like vulnerabilities that arise from detained people and their limited facility in English in many cases. All I want to say more about that, and counsel to the inquiry also talked about that, is the extent to which it can also be a basis of the mockery that some detained people experience. Their limited facility in English is often the subject of some of the mockery that goes on. Can I also deal with this? A particular complexity in this context arises because these vulnerabilities may combine with challenging behaviour, and sometimes very challenging behaviour. And that may sometimes be about mixing people who are vulnerable with people who are challenging. And we've heard reference to foreign national offenders and the difficulty that comes in from moving people from the prison estate into the immigration detention estate. And I've put in the paper some reference by way of context. This was 2017, and there were very dramatic problems in the prison estate in 2017, as I imagine, Chair, you already know. But it would be far too simplistic a response to say that that is the problem, that resolving that is part of the solution. Because often the most vulnerable individuals also have some kind of conviction. There are, of course, convictions and convictions, and we'll see that with cases where it is just documents offences, for example, without anything else. But often, the most vulnerable people have those kind of convictions as well. Because, Chair, the reality is that people are often both vulnerable and challenging, and people who have mental health problems are often the most challenging. And then that's people who are in extremis are often the most challenging. And then you get into people who have learning difficulties or who are neurodiverse. Problems in the prison system, at least as much of a problem in the immigration detention system. They may have poor coping skills. And we need to have a system that is designed around recognising that you can be both vulnerable and challenging at the same time. I've talked about the importance of relationships at paragraph 12 of my written paper. And that is something because we know that in any detention context, relationships are critical. For the most part, detention contexts are governed by reference to consent rather than imposing things on them. And most, if not every prison governor will tell you that. But those relationships become much more difficult when you're dealing with people who are mentally ill or who don't speak English or have other things going on of that kind. However, can I just give this particular example? It is much often in the prison context, a relationship is developed by giving somebody hope and talking to them and explaining to them what they need to do in order to progress. You can have the prison officer who says, look, I know something has gone wrong in your life, but what you need to do is put this behind you and do the following work. You now have these opportunities. Do the offending behaviour course. Take the educational opportunity. Do the work that might get you a job. Build the relationship that you need to build. Those things are much more difficult very often in the immigration context, where you can't give somebody hope because you're not supposed to be managing them towards release. You're managing them towards removal is the idea, and that's not something that they want, and may in fact not be something that's going to happen in any event because we know that the removal figures are very small. But if you can't give that individual hope, if you can't show them a way out, then that is going to undermine the possibility of building a relationship. It's going to undermine the basis upon which you administer the centre. But also, if you're in a situation where not only can you not give them that hope, you have to actively manage them towards a charter flight that's coming in a couple of days' time that you can't tell them about, so you have to keep that from them. So you have to be talking to them only for them to be forcibly taken to a flight a couple of days later. That will dramatically destroy the possibility of a relationship there. And that's something that, for example, Lee Hanford talks about in his interview with Verita. There's also a human response to all of that, I suggest, which is if you're facing with somebody, if you're faced with somebody who desperately needs help, and you're an officer, and you can't give that to them, then that is a very difficult thing to do. And one of the responses, one of the maladjusted responses that may flow from that, is that you say, well, I can't help you because you're not in fact deserving of help. And that's where the dynamic changes. That's where you're starting to cast somebody as other, somebody who doesn't deserve help. And in due course that develops into something where it's harder to be unpleasant to them. It's harder, it becomes easier to be unpleasant to them, sorry. It becomes easier to swear at them, and ultimately it becomes easier to use force on them. And that is all, these are the myriad of ways in which these matters develop, and the culture that we saw in Brook House develops. It's one of the things that happens in this context, and I'm now at paragraph 16, is that progress towards release or removal, part of that is also people bringing claims in order to stop their removal. And the Home Office is often very scathing about those attempts, saying that they're abusive and they are unmeritorious. But one has to remember that many of those claims are very well founded, because the original asylum claim that this individual may have advanced may not have been properly investigated or advanced. It may be that a highly sensitive trafficking claim didn't emerge the first time somebody came into the country, and it took time, often years, for something to emerge. But one just has to remember that the immigration system is another system that is under-resourced and creaking, and it often misses good claims. So the fact that somebody is bringing a claim may well mean, in fact, that it's a good claim, it just wasn't picked up the first time around. I've spoken about despair and hopelessness in this context. That too informs things, maladjusted response like drug taking. You know about new psychoactive substances, MPS and spice. We know that they're freely available in the immigration detention system, just as they are freely available in the prison system. They come in by other routes, including, and I've put references in the paper, via staff. But I emphasise this: those drugs are dangerous. They come in concentrations that are very often unknown. I suspect you have heard of the concept of the spice pig, where people bring the vulnerable detained person and give them the drugs, and then see how they react in order to see how concentrated or otherwise it is. Now, the results of that awful practice can be very dramatic and very loud, as some of the video footage shows, and all of that goes in to the atmosphere at Brook House, and we've seen the examples on the video footage, where you've got people who are very loud and very vulnerable and having those kinds of reactions, and it all contributes to the atmosphere that is, as I put it, ragged, febrile, often hostile, ultimately degrading, brutalising. How then are those problems, that range of complex problems and needs, being managed, and by whom? And the issue here that you then have is you've got people coming in who are have little or, if any, relevant experience and very little training. We see the reference in the Verita interviews where people are asked about what their experience was before they came to Brook House, and you're seeing references to people where they've worked in supermarkets or in other forms of retail. They've been baggage handlers at Gatwick. We see references to Pizza Hut and Argos. People have been doing painting and decorating. There are others who've done prison officers or worked in the military who bring aspects of that in. That can create its own problems. But it's a big ask of people who've done those kind of jobs to manage problems as complicated and as pronounced as these ones. And to do it, you'll note, on a flat rate, which actively disencourages people from staying in the job as they get more experience and perhaps better able to do it. That is what you need, a system that fosters that age and experience, because you need people who have the confidence and ultimately the authority, and by authority I mean moral authority, including the integrity, which needs people who, for example, will call out poor behaviour when they see it. That is not going to be fostered by a £25,000 flat rate. I've talked about training and the shortness of that. I'll leave that to the paper. We've talked about understaffing, 2 people on a wing of 126. A learned friend counsel to the inquiry covered that the other day. But keep in mind that when you've got insufficient staff, there are obvious and dramatic problems that generates, because there can be situations that are difficult and even dangerous. But even on a more mundane day-to-day level, if you don't have enough staff, you have staff who are ignoring basic requests because they don't have time to deal with them. you have staff who are responding to those requests too bluntly, or it means that it is taking people longer to get off a wing than it would otherwise take, which means they're getting frustrated and they're getting noisy. And I just flag that because we know, and it's referred to in the material at several stages, the noise of Brook House is astonishing, and there is case law on the relevance of noise in relation to Article 3 assessments, which we can come to in due course if necessary. But we were watching the video yesterday, the video that was taken in the stairwell, where you can hear the noise, despite there are closed doors, you can still hear the noise of the wings. There is something about the physical environment and the noise of Brook House that contributes to its, often we say, degrading nature. And I've just put in a reference there to Rule 3 of the detention centre rules, because that requires a relaxed regime with as much freedom of movement and association as possible, consistent with maintaining a safe and secure environment, and to encourage and assist detained persons to make the most productive use of their time, whilst respecting in particular their dignity and the right to individual expression. And I just flag that because when we watch those videos, one needs to keep in mind on whether or not really what we're seeing can be said to be compatible with that. I then talked about the shift hours. 13 and a half hours is a very long shift. Tired staff, along with inexperienced and ill-equipped staff, are not going to be improved in their ability to do that. Tired and inexperienced people will end up shouting. Shouting will become swearing. It may become more maladjusted and difficult responses. And when people are tired and they are looking and they're dealing with a situation, they may reach beyond their immediate tools, and they may reach out into the wider context and culture. And my learned friends from Duncan Lewis's team have been talking about the wider context and the hostile environment and the language about migration that is used by politicians and by the media. And that begins to inform the atmosphere. That begins to inform what is being said, because that is all the individuals are having to manage this process have to reach to, because they have nothing else instead, nothing that is less dysfunctional. When you have that, something else is going on there. Officers and other staff who are struggling with these the situations which they're having to manage may also feel the need to stick together. And we've seen issues in the material about the way cliques develop and the way cliques may develop around unsuitable people. And we've seen a remarkable consistency in what is being said about this. We get that from the Verita report. We are getting it from Nathan Ward evidence. We are getting it from now what Mary Bosworth says as well. That is what is happening, and this is a product of the situation in Brook House. It requires significant personal and professional presence and confidence to do the right thing in many of these circumstances. It does require that integrity, and that may all be conferred in a number of ways, by recruiting the right people, training them in the right way, enforcing and reinforcing proper behaviour, leading by example, and by providing constant and effective oversight. But as all of those reports say, was that happening in Brook House in 2017? And they were all consistently saying, no, it wasn't. They're all talking about the void in leadership. They're talking about the dysfunction at the senior management team level of G4S. And also, as my learned friend Ms Morris has just been pointing out, and referring to the Medway report, it is clear also from other sources. There is a reference, and I've put reference in the paper to the Jerry Petherick file note that goes back to 28th of October 2014, who talks about, I was becoming increasingly concerned about the stability of the management team at Gatwick. You put that together with what then happens in Medway. You then put it together with things like the whistleblowing complaints. It's not just Callum Tully. There are others, and I've put references in here to people like David Waldock, who talked about the incomprehensible levels of bullying at Brook House, and he wrote that in April 2017. That complaint refers to a whole series of individuals: Ben Saunders, Steve Skitt, DCO Gayatri Mehra, and Vanessa Smith of the Home Office. And Chair, just for your note, I'm now on paragraph 29 here, is those are all names that we now see regularly throughout these papers. Vanessa Smith is somebody who came across D687 only a very short period of time before the 13th of May incident, and she is linked in with Gayatri Mehra in that complaint. Gayatri Mehra is somebody who is cited in the GDWG evidence. We all see how that is linking together, and we see how the atmosphere is connected and amplifies itself. And we say, Chair, that the result of all of that mix, of all that coming together in that particular crucible, should surprise nobody. What happens is that the matters escalate, the temperature goes up, the problems that are presented don't get solved, they get aggravated, and you get all of the results that you then see. Mental ill health emerges or get worse. You see references, some people engage in food or fluid refusal, and then you see the language, which becomes, it may start as bleak humour, designed as a maladjusted coping mechanism. It then becomes swearing, it then becomes abuse, it may then become physical abuse. And I've made a note in this about the level of swearing. The reason why Professor Bosworth talks in her report about a completely unacceptable level of swearing, and she talks about that against detained people, and she talks about it between detained people, and she talks about it between staff. But we, you know that we've had a lot of video footage, and the key video footage is about 4 hours, and we've done a search, just done a keyword search on those transcripts, and you end up with 1,407 instances of the word fuck, 74 instances of the word cunt, and 21 for the word bitch. That is an extraordinarily high level of swearing. It has become endemic, and it is coarsening, and it is hardening, and it is leading back to that ragged, febrile, and hostile environment. And I flagged that, and this is the last point I'll make just before I finish for lunch, is that the reason why the language matters is because of the effect that it has, which is recognised as a matter of law. And between those paragraphs 33 through to 39, I set out why the language matters in an Article 3 context. It's partly because it evidences object and what is the purpose of the treatment, but it's also relevant in its own respect because of the impact that it has. And Chair, by my watch, I make that now about 2 minutes to 1, which is probably a good moment.
Thank you very much, Mr. Armstrong. We will reconvene at 2 o'clock.
Thank you very much.
Thank you.